Now, when it comes to fundamental rights, 1978 Constitution featured a chapter on fundamental rights. Now, if you remember what we studied under Unit 8, you are aware of the fact that the 72 Constitution was the first constitution which introduced fundamental rights to Sri Lanka, right? The Salisbury Constitution did not have a constitution, a chapter on fundamental rights. Then 72 Constitution introduced a chapter on fundamental rights, but the problem was it was not legally protected, nor it was enforceable, right? So it was merely a constitutional decoration, as some put it. So finally, in 1978, when we formed the Second Republican Constitution of Sri Lanka, they introduced a chapter on fundamental rights. And for the first time, we had a set of fundamental rights which were legally enforceable and legally protected. All right. So when it comes to 72 Constitution, Chapter 6 was the chapter that featured fundamental rights. Under 72, it was the third chapter, right? So from there itself, you can see that they have prioritized fundamental rights a little more. Like at a very early point of the Constitution, they give what fundamental rights are. Okay. So in Chapter 3, Article 10 to 16 provides all the fundamental rights the citizens of Sri Lanka have. Article 4D provides that all governmental institutes should respect and protect fundamental rights of the people. That is also important. Then, of course, you have the freedom of thought, conscience, and religion. So those are the first few fundamental rights. Then Article 14 onwards is about freedom of speech, assembly, association, and movement, etc. Right? Everything is provided. And there is a picture of the original constitution itself, right? So then after studying that, we can study about whatever the weaknesses and restrictions the fundamental rights chapter have, right? Then we'll study what is the protection mechanism. So first we need to have an idea about the background, how fundamental rights came to Sri Lanka, right? A comparison between the 72 and 78. Now, if this question ever comes to compare the 72 and 78, you have to compare the fact that in 72 Constitution 2 that we had a chapter, but that wasn't legally protected. This was legally protected. Hence, this was enforceable. Okay. Right. Let's get someone to read. Warner, have you fixed your mic situation, or is it still unable for you to read? Shall I get someone else to read? Right, okay. Yeah, your mic still doesn't work. Right, right. Afra, can you read? What about you? Does your mic work? Can others hear her? I am hearing her from a very distance. Can you speak closer to the microphone? Afra, I can hear you reading, but the volume is actually quite low, right? So it's okay, you figure out what's happening with your mic, that's okay. Can we get someone else, perhaps someone who doesn't read quite often? Patrick, would you like to read? Patrick, would you like to give it a go? Someone else, maybe Rashid?
Okay, sir. Fundamental rights. Fundamental rights were introduced to Sri Lanka for the first time under the 1972 First Republican Constitution. They are for the 1972 Constitution can be considered as one of the important landmarks in Sri Lankan constitutional history. However, despite this being a bold political feature, this fundamental rights chapter lacked a legal protection framework which made the entire constitutional chapter a mere constitutional declaration in general. It was urged that this chapter was simply a declaration of citizen rights rather than a constitutional fundamental rights chapter. Therefore, 1978 Constitution introduced a new fundamental rights chapter which was legally protected and enforceable. In contrast to the 72 Constitution, where the chapter 6 being fundamental rights, the 78 Constitution included its fundamental rights in chapter 3. It should be noted that this itself is a sign of fundamental rights being prioritized under 78 Constitution. Additionally, Article 3 of the very first chapter acknowledges fundamental rights as a part of the sovereignty of the people. In the Republic of Sri Lanka, is in the people and it's inalienable. Sovereignty includes the power of the government, fundamental rights, and the franchise. Article 4D also points out that all governmental institutes respects and protects the fundamental rights of the people. In Chapter 3, from Article 10 to 16, the fundamental rights of citizens are mentioned. They are as follows. Freedom of thoughts, conscience, and religion. 10. Every person is entitled to freedom of thoughts, conscience, and religion, including the freedom to have or to adopt a religion or belief of his choice, freedom from torture. No, 11. No person shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Right to equality. 12. 1. All persons are equal before the law and are entitled to the equal protection of the law, freedom from arbitrary arrest, detention, and punishment, and prohibition of retroactive penal legislation. 13.1. No person shall be arrested except according to the procedure established by law. Any person arrested shall be informed of the reason for his arrest. Freedom of speech, assembly, association, movement, etc. 14.1. Every citizen is entitled to A. The freedom of speech and expression, including publication. B. The freedom of peace assembly. C. The freedom of association. D. The freedom to form and join a trade union. E. The freedom either by himself or the association with others, and either in public or in private, to manifest his religion or belief in worship, observance, practice, or teaching. F. The freedom by himself or in association with others to enjoy and promote his culture and culture to use his own languages. G. The freedom to engage by himself or in association with others in any lawful occupation, profession, trade, business, or enterprise. H. The freedom of the movement of choosing his residence within Sri Lanka, and I. The freedom to return to Sri Lanka. A. A person who not being a citizen of any other country has been permanently and legally resident in Sri Lanka immediately prior to the commencement of the constitution and continues to be a resident shall be entitled for a period of 10 years from the commencement of the constitution to the rights declared and recognized by paragraph 1 of this article.
Right. Okay. Thanks, Rashid. Now you guys have a basic idea of what these rights are, right? So you don't have to exactly remember like each and every article. Okay, but keep in mind, first thing you need to know that how different this fundamental rights chapter from the 72 fundamental rights chapter. That's the first thing to remember. That's quite obvious if you understood, if you properly paid attention when we were studying Unit 8, that you know that that fundamental rights chapter lacked a legal protection. And the current 78 Constitution properly provides the legal protection that the previous Constitution lacked. Okay. And then you need to memorize which paragraph, which chapter it was. Under 72 it was chapter 6, and under 78 is chapter 3, right? And in the very beginning, in the fourth article itself, they say that the government institutes respect and protect the fundamental rights of people. Then chapter 3 is where that you get all these fundamental rights, right? 10 to 16 are the rights mentioned. So the first few is about like freedom of thought, conscience, and religion. 10 to 13 is about that. 14 onwards, it's about freedom of speech, assembly, association, movement, and all that. Okay. So these are the basic fundamental rights you get in Sri Lanka under the Sri Lankan Constitution. Okay. Right. So now we are about to move on to the weaknesses and the restrictions on fundamental rights. Okay. Before moving on to that, you guys need to properly understand what fundamental rights are. You need to have a basic idea of what fundamental rights are and how fundamental rights work. Okay. Now, this is not a part of the syllabus, right? I am just going to share my knowledge I've gained from my legal profession and give you a basic idea about how fundamental rights work. Okay, and then it will be much easier for you to understand, right? Just give me 1 second. Right, okay. So it's like this. Now, when it comes to fundamental rights means that the space you have to have your rights. Okay, so how can your rights be violated? That's the thing that you need to understand. Fundamental rights can only be violated by an executive or an administrative action. Like, it's okay even if you guys take notes while I explain this. Okay, fundamental rights can be violated with or by an administrative or an executive action, right? So who takes administrative or executive actions? The government. So fundamental rights, your fundamental rights can only be violated by the government only. Okay. Now I have shared some of my blog videos, my biker blog videos of me explaining this concept. So if you saw that particular blog I made about fundamental rights, that you must be clear with this at this point. Okay, so if I take an example, okay, now if I come, I am a person, I'm not a part of the government, I'm not a government servant, I'm not a part of the political executive, neither the permanent executive, right? I'm not the president or a minister or a prime minister, neither I do a government job. Okay, so if I come and sort of like stops you from leaving your place, leaving your house. If I keep a club and stay in front of your house and say that, you know, if you leave the place, I'm going to beat you up. And I use physical force on you, right? I use violence on you. So when that happens, is that a rights violation? A lot of people get this wrong. That's not a rights violation because I'm not representing the government. I am using my personal force to stop you, right? Which is why that sometimes, like, you know, you get into a fight with your neighbor or whatever, and you be like, oh, you're violating my fundamental rights. I'm going to courts. You're getting into a fight with your parents about your choices, and your parents sort of force you to make a certain decision. You'll be like, oh, you are violating my rights. I'm going to courts. No, your parents are. If your parents are sort of like forcing you to do something, if you are in a conflict with your neighbors or whatever, that is not a fundamental rights violation because that is not the government stopping you from doing whatever, right? That's not the government not allowing your space. So if I come and stop you from leaving the house by using criminal force, that is a criminal offense. That is not a rights violation. You just have to go and complain to the police. You have to call the police and dial 119 and complain, saying there is this person using criminal force, not letting me leave my house. So the police will arrest me, and that will go as a criminal case. That will go as a criminal proceeding. Okay, and I will be tried in a court. That's a criminal case. But let's say if a police officer comes and stops you from leaving the house, right? Or someone who works in a ministry. Let's say the divisional secretariat in your area sort of like takes an administrative action saying like, block your gate, something like that. That means the person who works for the government, who takes a salary from the government, who represents the government, who's a part of the political executive or the permanent executive, using the power they got from the government to stop your space. It's not someone, when the policeman comes and stops you, it's not the policeman using his personal force. Policeman uses his uniform. The police officer position he received from the government, he's misusing that. He's using the power that is given to him for being a part of the permanent executive or the political executive, one of the two, right? They are using the governmental power to limit your spaces. That is a rights violation. Understand? That is a difference. Let's say the same police officer, when he's off duty, police officer is off duty, he removes his uniform and he gets into civil clothes and he tries to stop you with a club. And now he's not using being a police officer's power. He's just using his own power because he's off duty. He's not wearing the uniform. He's not stopping you from leaving your house as a police officer. He's doing that as a person. Now that is a criminal offense. You're supposed to complain to the police, right? And it will be a criminal case. But if he is a police officer using his capacity as a police officer to stop your spaces, that is a fundamental rights violation. So in a fundamental rights violation case, right, when your fundamental rights are infringed, that means that you are taking steps against the government. You are suing the government, okay? Which is why we normally refer to it as fundamental rights can be violated with an administrative or an executive action. Either it's an executive action, that means it's done by the executive, or it is done by the permanent executive, administrative action. Understand? Right? That is a difference there. Okay. Right. So we can see that these rights violations are done by the government, by the executive, or by the administration of the country. Understand? Okay. Right. So now that you understand it's a government, when your fundamental rights are violated, what are the options you can take? Practically, the government has sort of limited your rights. Government has sort of limited your rights. So what do you do? What do you do when the government limits your rights? You need to take actions regarding the violation of your rights. I think the sun is... Okay. Right. So you have three options. Number one, you can file a petition on on fundamental rights to Supreme Court, right? You can go to Supreme Court and file a petition on fundamental rights. That's number one. Secondly, you can go to the Ombudsman. There is a position called the Ombudsman, which we will study, right? That person is in charge of taking all the disciplinary actions regarding public servants in the country. You can go to the Ombudsman. That's the second option. Thirdly, you can go to the Human Rights Commission. So those are the three available options if your fundamental rights are violated in our country. Okay. So let's see when this process works, what sort of weaknesses does it have? Now, for example, if you want to file a fundamental rights petition, you have to file it within 30 days of the day that your rights were infringed. 30 days is the limit. Okay. And if you go to Supreme Court with a fundamental rights petition, they will go through your petition, and if your rights are actually violated, they will deliver an order. They will order to whoever the officer who sort of like violated your rights to reverse that action or pay you compensation or whatever, right? If it is the ombudsman will do an investigation and he will notify the relevant officer, you've done something like this, it has violated this person's rights, so reverse that action or pay him compensation, like that. The only thing is, when the Supreme Court gives it, it's a court order, so the person is sort of bound to do that. If I'm a public officer, right, let's say I'm a public officer and I have violated Rifki's rights, so he goes to Supreme Court gives me a verdict saying, you need to reverse your decision. That's a court saying me that I have to reverse the decision, so I am bound to do that, otherwise court is going to punish me, right? But if the ombudsman tells me, that's not a courthouse, he's not a judge, so I am still bound to do that, but I can sort of neglect doing that. But if I do that, he will complain it to the parliament and the president saying, I gave this guy an order, he didn't really do it. Okay. So anyways, it's there in this note, then we can see how it works. So let's go back to the note.
Can't we go to police?
We can't go to the police. We can, but it doesn't make a difference because it's a rights violation, right? Because police is also part of the government and we are suing the government here. Understand? Imagine your rights are violated by a police officer himself. So it's pointless going to the police. You go to Supreme Court, which is the place that is there to protect your rights. Understand? That is the difference. If I come and do something to you, if I come and slap you or whatever, you can go to the police because it's a civilian violating another civilian space. But if a police officer or someone who works in the ministry or your Gravnildari or whoever comes and slaps you using the power that person has from the government, that's a government violating your space, not another civilian. Which means it's pointless going to the police because police is also part of the government. Then you go to the Supreme Court directly and say, this person violated my rights. So technically you are suing the government. You are suing the government. You are suing the executive, right? If a police officer comes and uses police officer's powers on you to violate your space, that means, like normally when you file a fundamental rights petition, you name everyone in that hierarchy. Whoever the police officer who slapped you or whatever is the first respondent. Then the officer in charge during that shift is the next respondent. The OIC of that police station is the next respondent. The DIG of that area is the next respondent. The IG, the policepati, right? The IG, Inspector General of Police, is the next respondent. And you can even nominate the minister who was in charge of the police also, because all of them are responsible for this one person using government's power on you. Okay. Technically speaking, as the president is the head of the government, head of the executive, even the president should be nominated. Like, president has judicial immunity, as we saw. We can't sue president, right? So under the 19th Amendment, at least this was taken out, and you could nominate the president also as a respondent in fundamental rights petitions in the 19th Amendment, but the 20th Amendment removed that again. Okay. Understand? That's why we can't go to the police. Pointless going to the police, right? Because it was the government you are trying to sue here. The government, the executive is the one that violated your rights, and you need to go to the judiciary for that matter. Understand? All right. Let's put the note back up. Right, the weaknesses. These are the weaknesses and whatever the restrictions the fundamental rights chapter has in our country. Okay. Right. We'll get someone to read. Sarah, can you read?
Okay. The weaknesses and the restrictions on fundamental rights. Although the fundamental rights of 1978 Constitution are much more powerful than the fundamental rights in the 72 Constitution, still the rights of the 78 Constitution also are subjected to certain reasonable restrictions. Therefore, in this chapter, also certain weaknesses can be seen. One of the most criticized weaknesses of the fundamental rights chapter is the exclusion of right to life, liberty, and safety. Despite including a vast range of different fundamental rights, these rights are not directly included in this chapter. In addition, right to property is also excluded in this chapter. However, it should be noted that the 1972 Constitution had extremely restricted fundamental rights comparing to the 78 Constitution. The fundamental rights which were given under Article 18.1 were only available subjected to all the restrictions given under Article 18.2. In contrast, the 78 Constitution did not carry such restrictions. However, certain restrictions such as national security, emergency situations are applicable under the 78 Constitution as well. According to the 78 Constitution, the fundamental rights are not absolute or supreme. However, the reasonably effective legal procedure is established to protect these fundamental rights. The main institute which is in charge of protecting fundamental rights is the Supreme Court of Sri Lanka, as provided by Article 17 and Article 126. A citizen may file a petition in case of an infringement or imminent infringement of their fundamental rights by an executive or an administrative action of the government. In addition, the Ombudsman and the Human Rights Commission of Sri Lanka are also involved in handling the protection of fundamental rights.
Right.
The role of this
I think you understand. Basically, these are the weaknesses and the restrictions. Like, they have an included right to life, liberty, safety. Those things are there. They are indirectly provided, not like directly provided. Okay. So there are some restrictions, but keep in mind that the 72 Constitution fundamental rights were like completely off. There was no protection whatsoever. So compared to that, this one is much better. And of course, what are the options you have available? As we saw, you can go to Supreme Court, you can go to the Ombudsman, or you can go to the Human Rights Commission. So the most important thing is the role of the Supreme Court when protecting fundamental rights. So let's have an idea on that first. Not sure we'll be able to finish Ombudsman, Human Rights Commission. If so, we'll finish that the next day. But role of the Supreme Court is something that you need to really understand. Okay. Right, Sarah, continue.
The role of the Supreme Court in protecting fundamental rights, as provided by Article 17 of the 1978 Constitution, the Supreme Court is given the power to handle the task of protecting fundamental rights of citizens of Sri Lanka. Therefore, any citizen who had their fundamental rights violated or about to be violated due to an executive action or an administrative action had the opportunity of filing a petition to Supreme Court as provided by Article 126. A petition on fundamental rights should be drafted within 1 month of rights violation and submitted to the Supreme Court. Initially, the petition should be examined by 2 Supreme Court judges and should be approved for a trial. Once the petition is approved, it is taken into consideration and the Supreme Court may examine the petition in a trial and deliver judgment within 2 months. The judgment may reject the claim of fundamental right or approve the claim of fundamental right. If the claim is approved, the Supreme Court may order the relevant executive or administrative authority to reverse their decision, or the court may grant a relief to the affected party. Therefore, it can be seen that the Fundamental Rights Chapter of the 1978 Constitution is more effective and practical than the 1972 Constitution. However, it should be noted that this chapter also has several weaknesses. One, this chapter of fundamental rights provides protection specifically over violations caused by executive and administrative actions. Therefore, it does not include violations caused by any law passed by the legislature. The task of protecting fundamental rights is only given to the Supreme Court of Sri Lanka, and no other court is given any authority. 3. The petition should be filed within 1 month of the violation, which might not be sufficient time in certain cases. The judgment of the court should be released within 2 months, which may not be sufficient time in certain cases. A third party is not being able to file fundamental rights petition on behalf of someone else. The right of a citizen to seek the protection of the Supreme Court in case of right violation not being recognized as right itself. Right to life, not being directly mentioned.
Right. So that's the role of the Supreme Court, right? And it has some couple of weaknesses. Things you need to understand about the role of the Supreme Court is basically that the Supreme Court is given power to handle tasks of protecting fundamental rights under Article 17. Okay, Article 17 is the one that specifically says you can go to the Supreme Court. And Article 126 says the Supreme Court has the power to go through a fundamental rights petition. Okay, so Article 17 and 126 are the two articles that gives the power to Supreme Court to handle these fundamental rights cases in Sri Lanka. All right. Then, as I mentioned before, you have to file it within 1 month. You have to go through a lawyer, you have to go through an attorney, and file a fundamental rights petition, and then you have to submit it to Supreme Court of Sri Lanka. So initially it is examined by 2 Supreme Court judges, and they approve it for a trial. Okay, first they go through it to see whether these like a properly done draft, properly drafted petition. If it is like, if it seems okay, then they approve that for a trial. So in the trial, it goes with 3 Supreme Court judges. It could be 5 sometimes, mostly 3, right? And they go through it in a trial and they deliver it within 2 months. The judgment comes within 2 months. Depending on some cases can go further now, but normally it's 2, right? 2 months. So the judgment can either reject this claim or approve the claim, right? The claim of fundamental rights. So if they approve the claim, if they reject the claim, of course, that's the end of the case, right? So if the claim is approved by the Supreme Court, they issue an order to that relevant executive or the administrative authority to reverse their decision or may grant to the affected party, right? Now, there can be certain actions that can be reversed, right? Like imagine something like, imagine that the local government authority in your area, urban council in your area has decided to start a garbage dump in front of your house. So exactly in front of your house, they come and they dump garbage, right? And you file a fundamental rights petition saying, oh, he has violated my rights. Then the Supreme Court may order and say that, okay, you know what? We order this local administration authority, local government authority to get rid of this dump, reverse the decision straight away. Okay. Or maybe like imagine a school not taking a child in based on some, like, you know, let's say the father is not whatever, you have all the qualifications, but the child is not taken in. Supreme Court may reverse that, say, no, you have to take this child into your school. All right. Fun fact, not a fun fact, interesting fact. There was this one student, if I remember correctly, she was from Visaka. She did O-levels and she had 8 A's and a B. Okay, 8 A's and a B. And the B was for English, it seems. And for English, she has received, excluding the essay, she was supposed to get 15 marks for the essay, right? For the essay, she has got 0 out of 15. She has got 0 out of 15 for the essay, but apparently she has 72 out of 85 for the rest of it. 72 out of 85 for the rest of the paper, which means that, you know, if she received like 3 marks out of 15 for that essay, she would have got an A. But the answer was she was given 0 marks. But the marking scheme actually said that if the student has written something, more than 5 words, the person is entitled to 2 marks. Okay. She was 73 marks. She was 2 marks short of the A, and the marking scheme said that if she has written something, now she has written an essay. We just have like those grammar mistakes and all that, but she was given 0 marks, and she argued saying the marking scheme says that, you know, I deserve 2 marks because I've written something, irrespective of grammar errors, spelling errors, and all that, if I've written something, I deserve 2 marks, and I didn't get it, right? I didn't get my marks. So she filed the case, a fundamental rights case, against education, against the person who marked her paper and whoever's in charge of that panel, and the education minister and everyone. So I was there when the verdict was given in that. I was in the Supreme Court when this was delivered. And the Supreme Court said, like, they violated this thing. They violated the marking scheme, and whoever the teacher, they have misused the powers, and the students' fundamental rights have been violated. And she was awarded those 2 marks, and she got an A, right? So there are certain things that can be reversed like that. If this is an action that could be reversed, it can be reversed for the person whose rights can be given. But there can be actions that can't be reversed. There can be something like, okay, there was another fundamental rights violation case that a policeman had slapped someone in front of BMICH because it turned out to be the traffic light was red. Sometimes when the traffic light is red, but the police officer there says you can go. So you are supposed to prioritize what the traffic officer says. So this one traffic officer have said that you can go while the red light is on. And but when he has gone, some other police officer has stopped and said, like, you drove when there was a red light going on, and the person has got off the vehicle, and this police officer has slapped the driver in front of BMICH. So he, of course, filed a fundamental rights petition saying the police violated his fundamental rights. Now, that is not something you can reverse. You can't reverse a slap, right? So for that, he was paid compensation. So if it is a reversible decision that it is reversed, if not, you are supposed to pay a compensation. Could be both. Sometimes, like, the action is reversed, and for whatever the loss that you suffered during that time, the court may grant you a relief as well. Okay, so that's how the Supreme Court handles such a case if the claim is approved. Okay, but there are some weaknesses too, right? First of all, the problem is that it only. Now, this is important. And in order to understand this point, you have to have the basic knowledge of those basics I normally teach before starting the class. Executive and administrative actions, right? Executive and administrative actions. The chapter of fundamental rights provides protection specifically over violations caused by executive and administrative actions. So, violations caused by any laws passed by the legislature, then no. You all know, because there are 2 ways of making laws. Number 1 is like executive making a decision and the legislature approving. Some of them are directly made by the executive. So you can only put fundamental rights petitions over whatever that comes directly from the executive or the administration. If it is something that violates your rights by getting it passed in the legislature, then you can't put fundamental rights petitions. Instead, what can you do? This is a question for smart people. Let's say if there are smart people in the class, you have to think a little out of the box. What is the only available option if there is something that violates your rights that is passed in the parliament? Anyone? Nobody? You have to go to Supreme Court and put a judicial preview action before it is passed in the legislature, saying it violates a fundamental right. That means it violates the constitution, right? So you have to go to Supreme Court, take a judicial preview power action, right, before it is passed in the legislature. That's the only thing you can do. All right. Okay. Then, of course, this is only given to Supreme Court of Sri Lanka. That's the thing. Like, even if you live in Jaffna or like Trinco or Hambantota or somewhere like other end of the country, you still have to come all the way to Colombo, Hulsdorf Supreme Court. There's only one court in Sri Lanka that has the authority to handle fundamental rights cases. Thirdly, this petition should be filed within 1 month of the violation. That is also not enough sufficient time in some cases, especially if you are coming from a rural area, you have to find a lawyer, you have to draft everything. Sometimes 1 month could not be enough. So much so recently, when the new constitution was in action, like you guys know that I went and suggested an electoral method. One of the things that we suggested, me and the legal team I was a part of, we suggested to increase this to 3 months in the whatever the new constitution that they are planning to bring. 1 month could not be enough in certain cases. Then the judgment of the court should be released within 2 months, which might be not sufficient in certain cases. As I told you, sometimes 2 months are not enough. There's a lot to be checked. Also, third party is not being able to file fundamental rights petition on behalf of someone else, right? You have to file the fundamental rights petition yourself, right? If let's say if Rifki's rights are violated, I can't go and talk to a lawyer. Okay, I of course can because I am an attorney, right? So I can file the case, but in that case, Rifki would be my client. Now, if let's say if Rifki's rights are violated, his mother can't come and tell me that my son's rights are violated. Can you file a case? Right? Rifki has to come. Like in practicality, yes, the mother can come and say, but my client should be the person whose rights are violated. And that is also a weakness because sometimes you might have to go on behalf of someone else because it could be someone who doesn't necessarily have the legal knowledge to file something like that. Then the right of a citizen to seek protection of Supreme Court right violation has not been recognized as a right itself. The fact that you can go to Supreme Court is not recognized as a right itself. And there is a problem there, right? It's just just a rhetorical sort of thing. It's just a logical error, right? The Constitution says that you can come to Supreme Court, but if you go in the proper way, that also should be included as a right. Like you have a right to seek the protection of Supreme Court if your rights are violated. That sentence isn't there in the Constitution. Then right to life not being directly mentioned, that is also another weakness. Right. So that's what you do. That's how you go to the Supreme Court if your rights are violated. Then we have another entity that we can go to, the Ombudsman. Before moving on to the Ombudsman, do you guys have any questions regarding the Supreme Court's role and how does the Supreme Court protect the fundamental rights in our country? Anyone, any questions? No, right? Okay. Right. Now let's take a look at the Ombudsman. Now, if you have heard of these ancient stories about like the folk stories and all that about Sri Lankan history, you all might have heard about this person called Duggannarala. Right? There is a person called Duggannarala in ancient castles, like palaces, right? So if a citizen has suffered any injustice from a particular person, right, who works for the government, you may go and you may complain to the king. But given that king is busy, king has appointed this person called Duggannarala. Like the name roughly translate into the person who listens to your complaints, your sad stories, whatever, right? Dugganna means like you take the sadness of the people. So this is like a modern version of Duggannarala. This person is there, like if you want to notify it to the king that the government had made some blunder and like the government has done some injustice to you with the administrative or executive decisions, you can complain it to the Ombudsman because the king in the sense like the president is too busy. All right. So this position is known as the Parliament Commissioner of Administration, right? Parliament Commissioner of Administration. පරිපාලන කටයුතු සඳහා වන පරිපාලන කටයුතු සඳහා වන පාර්ලිමේන්තු කොමසාරිස්වරයා. the Parliament Commission of Administration. Okay, so in addition to Supreme Court, this person also handles an important role in the this thing, right? When it comes to protecting fundamental rights. Okay, so initially this position was only appointed by president on president's sole discretion, and later on the president had to follow the recommendations of the Constitutional Council after the 17th and 19th amendments, right? So we shall look into the background of the Ombudsman, then we shall look at the appointment and removal method of the Ombudsman. After that, we can take a look at the powers and tasks of the Ombudsman. Okay. Right. Hishma, can you read?
The Ombudsman. As provided by Article 156, the position of the Ombudsman is created. This position is also known as Parliament Commissioner of Administration. In addition to the Supreme Court, the Ombudsman also fulfills an important role in protecting fundamental rights. Article 156(1) provides that the Parliament should take relevant steps regarding this position. Therefore, the power of this position was widened through Parliamentary Acts in 1991 and 1994, after being established also through a Parliamentary Act in 1987. The appointment and the removal of Ombudsman. The Ombudsman is appointed by the President, as provided by the original Constitution. Until the 17th and 19th Amendments, the President could appoint the Ombudsman on his sole discretion. However, following personnel shall not be appointed as the Ombudsman: a member of the Parliament, a staff member of the Parliament, an officer of a government corporation, a member of a local government authority or a similar authority. Also, it should be noted that the Ombudsman has no authority to work in any other position without the written approval of the President. The salary of the Ombudsman is decided by the Parliament and paid from the consolidated fund of the state. This salary can only be increased, not decreased. This position could be vacant. In cases of the death of the Ombudsman, the resignation through an official letter sent to the President, the retirement by the age of 70, removal by the President due to any mental or physical incapability, removal by the President due to a motion passed by the Parliament. It should be noted that after the 17th Amendment, the President had to appoint the Ombudsman on the recommendations of the Constitutional Council. This feature was practically implemented after the 19th Amendment in 2015.
Right. Okay, for today, we shall go through this part. Right? We shall go through the appointment and removal of the Ombudsman. Powers and tasks, we shall discuss it next week, because we have to discuss that in detail. So first thing you need to understand is this was established through a Parliamentary Act in 1987. Okay, so here's the thing. It says that the Ombudsman, position of Ombudsman is created under Article 156 of the Constitution. It says that the Parliament may take necessary steps. That's what it says, right? The Ombudsman position is recognized under the Article 156 of the Constitution, but the Constitution says that the Parliament may establish this position, right? So it's not like entirely a constitutional position. Constitution only recognizes this position, and the Parliament has the power to establish the position. So it was established in 1987 through a Parliamentary Act, right? After that, in 1991 and 1994, both years, it received even more vast power little by little. So before the 17th and 19th Amendment, President appointed whoever he wanted as the Ombudsman, except for these people. You can't appoint a member of the Parliament, a staff member of the Parliament, an officer of a governmental corporation, or a member of a local government authority or any similar authority. You can't appoint any of these people, right? Also, the Ombudsman does not have authority to work in any other position without the written approval of the President, right? Ombudsman, you have to work there. Salary of the Ombudsman is decided by the consolidated fund This is to make sure that whoever the government that is in power does not have the authority to meddle with that salary, okay, because it's paid from the consolidated fund. So this salary can only be increased, it can't be decreased. This position can be vacant if the ombudsman dies, obviously, or he resigns, or he retires at the age of 70. If the president removes because of any mental or physical incapability, or maybe the president could remove if the parliament passes a motion with an absolute majority, you can remove. So after the 17th Amendment, the ombudsman had to be recommended by the Constitutional Council, and however, it was practically functioned after the 19th Amendment in 2015. Okay.